There we go.
Morning, everybody. I'm delighted to be with you. I'm Bob Gleason, here today talking with Frank. We're at the Thursday Milwaukee snack program. The purpose of these is really to try to replace that feeling that we had when we were sitting next to each other at Rotary and you meet somebody new and you talk with them and learn new things about what they did. It's less formal than the normal Tuesday programs, no pledge, no invocation, no club business. Frank will talk about 30 minutes and then we go to questions and answers from you, the audience, and you can type those into the chat area. I'll read those as we go along. Next week, we're going to be talking about Milwaukee sculpture with Mary Lou Node. So I think that will be a wonderful program and I encourage you to tune in. So we all think of Frank, everybody knows Frank, as being this world heavyweight, for real, defense attorney. But Frank didn't start out as a defense attorney, did you, Frank?
No, I didn't, Bob. No, as a matter of fact, I started out as kind of a struggling lawyer trying to figure out how I was going to make enough money to pay the mortgage payment on my house in Fox Point.
Okay. So, but you really did start out not as in defense, you went into being a prosecutor.
That's right. I mean, it's a curious story, but in May of 1963, Bob, I got a call from a man by the name of Patrick Lucy. Pat was the chairman of the Democratic Party for the state of Wisconsin. He thereafter became governor of the state of Wisconsin. He said, Frank, I'd like to meet you for lunch over at the Schrader Hotel. I have a proposal for you. I went over to the Schrader Hotel, which is now the Hilton Hotel over on Wisconsin and 4th Street, and sat in the dining room. And he said, I would like you to take over responsibility for the annual Jefferson-Jackson Day dinner, which is a big fundraiser for the Wisconsin Democrats. It's held at the Milwaukee Arena, and this year we're having as our guest speaker, Vice President of the United States, Lyndon Johnson. I said, well, you know, Pat, I said, I'm honored by the request, but I'm struggling to make a living as a lawyer, and I'm aware of the fact there's an opening in the U.S. Attorney's Office in Milwaukee. If you could help me get a job as an assistant U.S. attorney, I would do anything you asked. He asked the maitre d' to come over to the table, and he brought an old-fashioned telephone, and he started to place a call. The call went something like this. Hey, Bobby, it's Pat. Yeah, how's Jack doing? Oh, great. Listen, I'm sorry to bother you, but I need a little bit of a favor. I've got a brilliant young lawyer here who's done a lot of stuff for us, and he tells me that there's an opening in the U.S. Attorney's Office in Milwaukee, and he'd love to have a crack at that job. I'm wondering whether or not you can help me out and help him out and get that job. Really? Well, what would he do? Thanks so much. Oh, yeah, say hi to Jack. Goodbye. He said, Frank, you got the job. Tomorrow, call Jim Brennan. He's the U.S. attorney. Bobby Kenny is going to be calling him right now to see to it that he gives you the job. So I started out then in the fall of 1963 as an assistant United States attorney after I was the chairperson and speaker at this JJ dinner, which Lyndon Johnson attended. And as those of you who follow politics may recall, some of you may be too young, but that year, John F. Kennedy was assassinated and Lyndon Johnson became the president and I became an assistant U.S. attorney.
That's cool. You know, it's just interesting how people get a start and then become successful. But did you have any interesting cases as prosecutor?
Well, I'll tell you what, I learned how to be a courtroom lawyer as an assistant United States attorney. During the 5 years that I spent in that office, we only had 4 assistants to begin with and then 5. Today they have about 55 in the same office. They prosecute about the same number of cases. But I had one case that was extraordinarily interesting, and I'd like to talk about that briefly today, Bob. I was asked by my boss, Jim Brennan, to take over the prosecution of a man by the name of Frank Peter Balistreri. Frank Peter Balistreri was ostensibly the head of the mafia in Milwaukee. And he had been indicted by a grand jury in Milwaukee on 3 counts. The first count was obstructing the function of the government in the collection of taxes. The second and third counts were tax evasion for the years 1957 and 1958. There had been a whole bunch of stuff that had occurred prior to the case getting to trial, one of the things that had happened was that Balistreri brought a motion for a change of venue. In other words, he requested the judge in Wisconsin to move the case to someplace out of Wisconsin because of his allegation that there had been an overwhelming volume of publicity in the city and in the state identifying him as a mafia gangster. That request was granted by the judges in Wisconsin, and the case was transferred to the Southern District of Illinois. So when this case was to be scheduled for trial, I got in my car and I went down to Springfield, Illinois. On the way down to Springfield, Illinois, Bob, we stopped in Peoria, Illinois, and we had dinner in a restaurant. In attendance at the dinner in the restaurant was the United States Attorney from the Southern District of Illinois, a man by the name of Charlie Siragusa, who was the head of the Organized Crime Task Force in the city of Chicago, my boss, Jim Brennan, and a member of the IRS or the Justice Department Tax Division in Washington. We're sitting having dinner in this restaurant in Peoria, and the maitre d' comes over to our
Italian restaurant.
It was not an Italian restaurant. The maitre d' walked over to the table and he says, "Is there by chance a person here by the name of Frank Gimbel?" I said, "Yes, my name is Frank Gimbel. I have a phone call for you, Mr. Gimbel." So I was absolutely shocked and surprised that I would get a phone call in a restaurant that I didn't even know that I was going to be attending. I walked out into the hallway and the maitre d' handed me the phone. I picked it up and said, "Hello." The voice on the other end said, "Is this Frank Gimbel?" I said, "Yes." He says, "You don't know me. My name is Mitch Rogovin. I am the Assistant Attorney General of the United States in charge of the tax division. I know that you're going to Springfield and you're supposed to start the Balistreri case on Monday morning. I'm asking you to get up in front of the court and seek an adjournment of the trial." I said, "Well, Mitch, I don't know you, but what would I tell the judge to justify my request for an adjournment of the trial?" He says, "I can't tell you that." I said, "I'm sorry, Mitch." I said, "But I have a great relationship with this judge. I've been down here several times. I tried a jury case in front of him in Milwaukee, and I don't feel comfortable getting up in front of a judge and saying that the case should be adjourned. It had been scheduled for about 5 months ahead of this particular Monday, and Balistreri is going to be there with a battery of lawyers." "Well," he says, "I'll tell you what I'm going to do. I'm going to give you more information about this tomorrow. I'll call you in your hotel." I said, "Do you know where I'm staying?" He says, "Yes." The phone conversation was over. I went back to the table and Jim Brennan said, "Who was that?" And I said, "You're not going to believe this. It was an assistant attorney general from Washington and they want me to adjourn the trial on Monday without a reason." I passed out at that point in time, Bob. I needed you. I was a young guy. I'm 26 years old and I don't know what the heck's going on. But they revived me. The paramedics came. They wanted to take me out. I really did. This is a true story. And I said, "No, I don't want to go over to the hospital. I'm okay. I'm fine. I'm okay." And so we finished our dinner. We went on into Springfield, and I went to my hotel room. And sure enough, the next morning, I get a call from Mitch Rogovin. And here's what he told me. He said, "Frank, we have discovered that Mr. Balistreri last week, when he was moving out of his office on Downer Avenue in Milwaukee, discovered a microphone hidden behind the paneling in his wall. And we didn't know what we should do about that. His lawyer has that microphone with him. The Attorney General, Ramsey Clark, and I, and several of other people, high officials in the Justice Department, have now decided that we want you to disclose this on Monday. And we'll talk about a strategy when I see you tomorrow. I'm flying into Springfield today." So Mitch Rogovin and another lawyer from the Justice Department came to Springfield, and on Sunday morning we met in a restaurant, and we devised a strategy to go in and make a disclosure about this wiretap that the FBI had conducted. And what thereafter happened was that on Monday morning, I appeared in the courtroom. They had about 100 people there who were prospective jurors. Mr. Balistreri was sitting at the defense counsel table, He had two other Milwaukee lawyers with him, and a Chicago lawyer who was his chief lawyer, and a man named Maurice Walsh, who was like a prime criminal defense lawyer in Chicago, had spent 10 years as the head of the criminal prosecution division of the U.S. Attorney's Office in Milwaukee. He was about a 6'4" guy, weighed about 250 pounds, very imposing guy. I got up after the judge called the case, and I said, Your Honor, in advance of proceeding with the selection of the jury, I would like to have the court empty the courtroom. I have something to say. So the judge says, okay, bailiff, take all these jurors out of here. What do you have to say? I said, Your Honor, it has come to the attention of the Justice Department that Mr. Balistreri recovered an electronic eavesdropping device from his office, and I am here to tell you that that eavesdropping was conducted by the Federal Bureau of Investigation. It was not legal, but the case that I'm here to prosecute was investigated by the Internal Revenue Service, and I'm willing to present evidence to you in the form of what we'll say is a motion to suppress the evidence that was acquired by this illegal source, and move on with this case, pick a jury, and try the case. Judge turns to Mr. Walsh. Mr. Walsh, what do you have to say about that? Well, this big imposing guy gets up and he walks to the bench. He has a paper bag, like a grocery bag. He slams it down on the bench in front of the judge, and he says, I have done this, that, and the other thing in my experience, and I've been, this is the most outrageous case of government misconduct that I've ever heard. This prosecutor or persecutor's suggestion is outrageous. This case should be dismissed now, and the government should be required to pay costs to my client. The judge says, I think Mr. Gimbel's proposal is quite reasonable. So, Mr. Walsh, we're not going to dismiss this case. We're going to have a motion to suppress hearing. The question that I have for you now is, are you ready to start that, Mr. Gimbel, this afternoon, or do you want some more time to prepare? I said, we'll start it this afternoon. Walsh, what about you? We'll start it this afternoon. Thereafter, on the first day of this big trial, I put on every single person who did anything at all from the IRS to investigate this tax case, and we made available to the defense the FBI agents who were involved in planting this illegal eavesdropping device. This is in the 1960s. The microphone was this big. The way it was installed, it had a line that ran from the hearing device out to a telephone pole, and it went to downtown to the FBI office where they surveilled him for several months. Well, after 5 weeks of testimony in the motion to suppress hearing, the judge ruled that count 1 of the case, which was the count charging him with impeding the IRS ability to investigate the taxes of this individual, would be separated from the case, and we go to trial on counts 2 and 3, which were the income tax evasion cases, which we started to do. That trial lasted about 8 weeks, during the middle of which Mr. Walsh suffered a heart attack. He had a lawyer come to Springfield, to ask the judge to continue the case till Walsh recovered. The judge granted him a continuance in the middle of the trial for 4 weeks. We picked up the case. The jury came back in April with a guilty verdict on the 2 counts. Thereafter, that case went to the 7th Circuit Court of Appeals. They affirmed the conviction. Mr. Balistreri took the case to the United States Supreme Court. The United States Supreme Court at first blush said, we're not going to look at this case. Someone from the government went to the United States Supreme Court. We found additional eavesdropping information on Mr. Balistreri. We want you to send the case back down to the trial court. So the Supreme Court vacated the 7th Circuit's affirmance of his conviction. It went back to Judge Poos. He reviewed the thing. He said everything is hunky-dory with the conviction. It went back to the 7th Circuit. They affirmed it. So this case, which started in the early 1960s, was ultimately concluded by the 7th Circuit Court of Appeals saying the conviction of Mr. Balistreri is affirmed. He will do his sentence, 2 years in prison, $5,000 fine on each of the 2 income tax cases. And he started his sentence in, I believe that it was 1969 or 70.
Wow. 5 or 6 years after you started this.
That's correct. So the point of the matter is that this was a very dramatic case, and it showed all kinds of mischief that the government does with regard to people who are targets of their behavior.
Yeah, but you were also a 26-year-old young lawyer who got a major mafia guy.
Yes, I felt very good, but I have to say that between the time that I started the Ballestori case in 1967 and the time that I tried the Ballestori case, I had tried probably 20 or 30 jury trials. I was trying a jury trial a month in that office, and it taught me how to be a trial lawyer, because the best way to learn anything is get in the middle of something and start doing it.
Oh, wow, that's interesting. But what a thrill to put a guy like that.
It was a great adventure, Bob, and you know, I could talk about the Ballestori case and the ins and outs and some little secret footnotes to the case all morning and all afternoon, but I think we've got some other stuff we want to hit on.
So you almost got to the Supreme Court with this case.
I would not have handled it, because
have you ever handled the course? What's up?
Yes.
What kind? Really?
Well, I did get to the United States Supreme Court, and that's a curious case.
Frank and a curious case. What a novel idea.
Now I'm a criminal defense lawyer, and I get a call from a lady who is the secretary of the city attorney of the city of Milwaukee, and she says, Mr. Gimbel, would you see my husband, please? He's been indicted by the federal government in the Eastern District of Wisconsin for taking a bribe. And his name was Fred Matthews. Well, Fred Matthews came to my office, and it turns out that Fred was working for the Small Business Administration, and he was a business specialist advisor to minority businesses who are attempting to get business with some level of government assistance. In the portfolio of Mr. Matthews' case, there was an African-American businessman who was in the business of creating knitwear, like scarves and sweaters and caps for the Navy. And at a point in time in the relationship between Mr. Matthews and this man who had this small business, they developed a very close personal friendship. They went out socially with wives. And from time to time, my client asked his businessman friend for loans, and he got a loan from him. Down the road, Mr. DeShazer, who ran this minority-owned small business, ran into a big problem with the Navy. He wasn't delivering the knit goods that he had been contracted to produce on time. And so the Navy said, we're going to cancel our contract with you. And he said, please don't. He says, I've had a problem getting funds through the SBA, and I think part of it is because one of the people there is trying to hold me up for some money. Well, we better bring the FBI in on this thing. So lo and behold, the SBA bring in the FBI, and the FBI take Mr. DeShazer, and they say, we're going to script you, and we're going to see if we can get Mr. Matthews to say something or do something incriminating on a wire that you're going to be wearing. So they wired Mr. DeShazer. Mr. DeShazer calls Mr. Matthews, and he says, hey, Fred, he says, I've got some very, very interesting news. He said, I was cleaning out my garage, we're moving, and I found an envelope that I never knew that I had, and it contained $20,000 in cash. Now, I need $12,000 of that cash, but $8,000 I think I can make available to you for a loan. Are you still interested in that loan? I am. Well, why don't we meet and I'll give you the money. So they set a couple of different meetings, and lo and behold, they meet across the street from the federal building at the Pfister Hotel in the, at that time known as the Greenery Restaurant. And they're sitting at a table, and Mr. DeShazer says to Matthews, I've got this money, here it is. Now you understand, I'm loaning this money because you have asked me over time to help you out and loan you money, and you've always been helpful to me in handling the SBA piece of my business. He takes the envelope, he gets up, the lunch is over, he walks out, bingo, handcuffs, FBI's waiting in the hallway. He hires me, and I go in to defend him on the case of taking a bribe. At that point in time, we were of the view that we could assert in this case the defense of entrapment, that really Mr. Matthews, who at that point in time didn't have a relationship with DeShazer through his position as an SBA advisor, was just a friend of his. And while, yes, he did take money, and yes, he did work for the government, he never intended that the money that he got from DeShazer was going to be money that would be essentially a payoff to influence how the SBA would treat DeShazer in his contract with the Navy. We had a jury trial in Milwaukee. The trial judge refused to allow the jury to consider entrapment in that case because the judge said, Mr. Matthews doesn't admit that he did all the elements of the crime. The jury came back with a guilty verdict. The case went to the Seventh Circuit Court of Appeals. The Seventh Circuit Court of Appeals was presented with the issue of whether or not the judge should have given the entrapment instruction in that case to the jury. The Seventh Circuit Court of Appeals agreed with the trial judge and said, no, what the trial judge did was perfectly fine. Now, Mr. Matthews comes to me and he says, do we have anything else we can do? I said, well, it's a long shot, but we can file a petition for certiorari with the United States Supreme Court and ask them to take your case, but you're out of money. So I'm going to also have to ask the Supreme Court to treat you as a pauper and ask them to appoint me as your lawyer. I filed that petition for certiorari, and to my shock and surprise, the Supreme Court granted the ability of Mr. Matthews to get into the Supreme Court to hear the issue of whether or not the trial court should have allowed the entrapment instruction to go to the jury.
Now, your client has been convicted of all this.
He's been convicted
twice.
He's been convicted, and his conviction has been affirmed by the Court of Appeals. Now, his sentence, curious sentence, I wish I could get a sentence like that for one of my clients today. Judge Curran gave him 3 years probation, within which he was to serve 2 years of house arrest. House arrest is you go out of the house to go to work in the morning, you get home after work, you stay in your house all other times, you can't socialize for 2 years, which he served that sentence. We get to the Supreme Court, and I had 2 lawyers in my firm who were working on the brief, and one of the lawyers actually had tried the case, Jeff Kaufman. He was a brilliant young lawyer, tragically lost his life to ALS several years ago. But I get to the Supreme Court, I go to the clerk's office. My name is Frank Gimbel. I've got the case of the United States versus Matthews. The clerk says, oh, Mr. Gimbel, he says, what a lucky day for you. This is your first time in the United States Supreme Court. You're the second case. The first case is the case of Jerry Falwell versus Larry Flint.
Oh, wow.
Wow. So my wife, who is 7 months pregnant with my youngest son, Noah, Jeff Kaufman and his wife, Jan, and Marna Tess-Mattner and her husband, Kemp, all come into the Supreme Court chambers. At that time, they didn't have security like they do today, and the courtroom is wall-to-wall people, and they've got illustrators in the courtroom, and seated in the front row is the Reverend Jerry Falwell, Sr., not Junior, who fools around with pool boys. And into the courtroom before the argument begins is Larry Flint in a gold-plated wheelchair. Well, I could talk for an hour and a half about that argument, but you can see the movie. Woody Harrelson, it was in the movie, and as it turns out, the United States Supreme Court reversed the case, which was in favor of Falwell, and ruled in favor of Flint. Now, I'm told as soon as the case before you was over, you stand up and you say, Mr. Chief Justice, my name is Franklyn Gimbel. I'm here in the case of the United States versus Matthews, and you'll start your argument. So I did. I got up as I was instructed by the clerk of court, and the courtroom is starting to empty out with all the people, and it's as though there were a ship in harbor with the rats leaving the ship. Everybody's pouring out. I did as I was told, and I said, Mr. Chief Justice, it was Chief Justice Rehnquist from Shorewood, Wisconsin, who was the Chief Justice of the Supreme Court in this hearing in 1987. And I said, he said, sit down, Mr. Gimbel, and just wait till this place settles down. I said, oh, I thought all these people were here for me. Ha ha. So I had more balls than I had brains, but at that time, it was an interesting start. Needless to say, I got up and started to make my argument. Now, before I went to the Supreme Court, I had been in the Supreme Court in the state of Wisconsin. I'd been in appellate courts, federal appellate courts around the country. The Supreme Court's a big deal for a lawyer. Let me tell you, there aren't too many lawyers that get to the Supreme Court. I called a friend of mine who had clerked for a justice of the Supreme Court, and I said, Whit, what should I look forward to when I get to the Supreme Court on this case? He asked what the case was about. He said, you know, this particular Supreme Court, they're not interested in criminal cases very much. You're going to get a softball question from Thurgood Marshall. You're going to get a softball question from Justice Brennan. He says, and you'll be able to give whatever your spiel is, you'll be able to do it in your 30 minutes that are allotted to you. So I get up and I say, Mr. Chief Justice, may it please the court, I'm Franklyn Gimbel, I'm here for Fred Matthews. One of the justices says, why did we let this case in, Mr. Gimbel? I don't understand what you're doing here. It wasn't Marshall, it wasn't Brennan, it wasn't a softball. So I started to answer him. And then thereafter, the justices came after me like it was a ping pong game and I was the ball, going from side to side to side to side until I got rescued by Justice Sandra Day O'Connor. She jumped in and she kind of, even though I thought I was doing pretty well with these justices, she said, you know, I think I'm understanding what you have to say, Mr. Gimbel. What you're really saying is this. And so she kind of brought to a kind of a very, very summary view of what my point of view was. And my point of view was that the way that the entrapment instruction is treated around the country, if you are in California and you say you were entrapped, but you weren't even there when the crime was committed, the jury gets to decide whether you were entrapped. If you're on the East Coast or in the Middle South, if you went and said, I did these deeds, but I didn't intend to commit the crime, which was the fact in the Matthews case, the jury gets to get the case. But the right-wing point of view on entrapment was in the Midwest, in the Seventh Circuit. And my Seventh Circuit decision said, if you don't admit I did the crime, but the government made me do it, the jury can't consider it. The Supreme Court in a 6-2 decision, the ninth justice wasn't on at the time, it was Kennedy, decided in my favor. They reversed the case. They said Mr. Matthews should have had the jury in his trial decided by the jury, and they vacated his conviction. The government didn't retry him because he had already done his 2 years of house arrest. Extraordinarily interesting experience.
What a tale. Hard to believe. The courage to take somebody who was basically convicted and then affirmed and go to the Supreme Court because you think you're right. That's what makes a really good lawyer, and that's why you have your reputation. So have you had fun doing this over your career?
Well, the answer to that question, Bob, is fun would probably be a word that some people might say is inapplicable to the kind of cases you have. The third case I was going to talk about today, but we're out of time, was I represent a guy by the name of John Spooner. That was a few years ago. John Spooner lived on the south side in a rather dilapidated neighborhood, and he had had his house burglarized a number of times. So he established a kind of a self-made and ornate defense system, including video cameras all over his house. And he reached the conclusion that two young African-American boys who lived next door to him had attempted to burglarize his house a couple of days earlier and take guns from his house. So he decided that he was going to exercise his vigilante justice. He went outside, he confronted these two young men, and he shot and killed the 13-year-old boy, and it was on videotape. And then he aimed the gun at the guy's mother and at this other guy. The gun jammed. He sat down on his porch. The poor young man, after he was shot, ran about a half a block, dropped dead. And I was asked to take the case by a retired deputy sheriff in Milwaukee. They didn't have a lot of money. They said, we'll give you his house or whatever you get from the house. I took the case and tried the case on the basis of an insanity plea. And while I can't get into the details because we don't have any time, at the end of the day, in the middle of the case, I had a psychiatrist to say that he was a person who suffered from a diagnosable mental illness and disease. And as a consequence of that mental illness or disease, he was unable to distinguish the wrongfulness of his conduct. The state had two psychiatrists or psychologists and psychiatrists who said that didn't apply to him. He wasn't crazy, and he knew what he was doing. That was the case in the middle of the trial. The defendant turned to me and said, you know, I think you sold me out for the cops. And as a result, I'm going to tell the jury my side of the story and not let you run the case anymore. I'm going to run the case. Well, to make a long story very, very short, he got on the witness stand against the advice of me, against the advice of the trial judge in the case, and he buried himself. The jury was out for 5 minutes, found that he was sane. The judge sentenced him to life in prison without parole. He was 77 years old when he walked into the prison as a white man who had assassinated an African-American person. So for all intents and purposes, he was segregated from the population of the prison, and he died last year in prison. Maybe some kind of poetic justice.
Interesting, interesting. If you have questions, feel free to type them into the chat, and I can read the screen from here, and I'll read them. I don't see any right now. But this has been interesting, Frank. It's also a topic that's a little hard to ask questions because it's sort of case specific, and you know, you got to sit in the room and catch the infectiousness of this. He acts like he's about 42 years old. He's so damned excited by these cases, and they just thrill him. But that's what gives you the reputation, and why we still see your name on the front page of the Journal Sentinel today. Well, not today, but this week.
Well, you know, my beautiful wife, you know, she said to me when I was hired by the outgoing police chief, Morales, to be his lawyer, that she said, boy, you're really high when I had an event in that matter. And I said, there is something about having an opportunity when you're 84 years old, you're a cancer survivor, to be relevant again as a lawyer. And that's how I feel, Bob. I feel like, you know, we have within ourselves a lot of untapped energy, and I love what I do. I'm not always the most popular guy in town. If people decide to judge me by the behavior of my clients, I've always tried to draw a line and say, please understand that because I represent somebody who actually brought about the death of another person, I'm not in favor of killing people. If I represent somebody who scammed people out of money, I'm not in favor of scamming people out of money. If someone's accused of cheating the government this way or another way, I'm not in favor of cheating the government this way or another way. But the only way that the system of government in our country works, where the presumption of innocence has some level of reasonableness, is to have lawyers who are engaged and stand the ground as the champion of the people who are not popular, who are by and large targets of what might be some lynch mob mentality out there. And I can understand the lynch mob mentality sometimes, but I can't accept that that's real, reasonable, or a way to deal with people if we want to have equal justice in the country.
Well, justice is important, and thank you for doing all the work you've done, because our legal system and the presumption of innocence has gotten us to this great country that we are. And let us hope that
it doesn't always work.
But let us hope it continues. Thank you. Thank you, everyone. Oh, Frank, any comments on events this month? I can't see who wrote that. Lloyd wrote that.
Well, as you know, I am representing Chief Morales. I think that the police interaction with George Floyd in Minneapolis and with young Mr. Blake in Kenosha are outrageous and reprehensible. I think that there is a need for us to be introspective and accept the reality that racism exists in this country, and how it manifests itself in its ugliest form is when people in authority treat people who are minorities, who don't have affluence, who don't have education, and who have skin that makes them easy to identify of a different color, are the victims of community views that are outrageous and inconsistent with due process. and they're very offensive. On the other hand, I also think that we need to have civility in our interaction between all of us. And I don't think that an appropriate way to protest against institutional racism is to burn down the buildings of government and or private citizens. So we are going through a time where I think there is going to be some level of introspection of the behavior of those people of authority in our communities. I like to think that the ultimate leaders of our country at the national, state, and local level will be appreciative of the fact that discrimination based on race or ethnicity or on economic circumstances has no place in this country, and that they'll act responsibly. I'm not convinced, however, that that's universally true today.
Yes, okay, thank you very much. Another question, who has been your most fun client?
Well, I represented.
It said fun and interesting, so
I
just went with the adjective fun.
Some of you might remember there was a restaurant in town called Sally's. Sally Papia was a client of mine. She was indicted as a part of a conspiracy.
No, she's also mafia. So one time you're
well, I wouldn't say she's mafia. She was certainly a friend of people who were alleged to have been a part of the mafia families.
Oh, okay.
But she hosted a restaurant that was extraordinarily popular for people coming to Milwaukee. You always got extraordinary food, extraordinary service, hard to get a reservation. But as her lawyer, we always had a table and we got good service, and I never got a bill. But I did defend her in a case where she was indicted with 5 other guys, and it looked like something out of The Godfather. The cast of characters were a bunch of Italians, and among the lawyers was myself representing her. Joe Balistreri, who's Frank Balistreri's son, was representing a defendant. Jerry Boyle represented a defendant. Tom Doherty represented a defendant. Richard Riley represented a defendant. The trial was one within which the jury was sequestered. What that means is that the jury, after they were sworn into the box, and it took us about 8 days to pick a jury, were kept in a hotel room for the length of the trial, and the trial lasted about 6 weeks. And at the end of the day, everybody was convicted of something except Jimmy Gennaro. His case was thrown out by the judge midstream, and I did represent Jimmy Gennaro in some other case. And at the end of the day, Sally, who testified in the case, was not convicted of the conspiracy to burn down the restaurant of one of her cooks, but she was convicted of a part of a relationship that had to do with the collection of a debt. And she was sentenced to 2 months in jail and under the Huber law. So Judge Reynolds at the time authorized that she could go to jail at the close of the restaurant day, which was 2 in the morning, and get out at the beginning of the restaurant day, which was 7 o'clock in the morning the next day. And the person who was the Waukesha County jailer, who was in charge of running that program, liked to eat at Sally's. So sometimes he would say, why don't you just stay home today? That was a fun case. Sally got indicted another time on a case involving union corruption. And this was a case where the boys, I'll call them the boys, were not feeling too well about Sally's behavior in the community. And so they really set her up for this case. And she was convicted and she was sent to prison. And I actually escorted her, took her to prison, and I visited her in prison. It was a very interesting experience to go to a women's federal prison. And that could be the subject of another day's conversation. But Sally was a fun lady. She was a person who ran an outstanding restaurant. She was a tough cookie, but she treated her lawyer with respect and affection.
Interesting.
Litigation, we do have people who in their fields. To a certain extent, that's good for the consuming public, if the consuming public has the wherewithal to hire lawyers who have developed a reputation and experience in a specialized area. But for many people, access to the courts and access to justice, if you will, really has a dollar sign on it, and the costs of getting well represented have skyrocketed. A case which in the 1960s or 70s someone could have defended for $10,000 today would be $100,000, and it's because of the complexity of cases today, and it's because of the high overhead of offices today and the high cost of living. So things have changed. So if you want to be a lawyer today, I think you ought to kind of set your sights on what part of the law you'd like to practice in. Our law firm, for example, we have 18 lawyers, and of the 18 lawyers, some are assigned to family law, some are assigned to personal injury law, some are assigned to employment law. A few of us are in the criminal defense area. Sometimes we trespass into other areas and take cases if they have trials. But it's become a much more specialized profession, and a profession that tragically and unfortunately, in my view, limits access to the average person to get the best that there is, with no denigration to public defenders and people who work to provide legal services for little or no cost. There still is a difference in the experience level and in outcomes for the lawyers that you select. So like every profession, the passage of time doesn't necessarily equate to better service for less money.
Okay, thank you very much, Frank. We both got some philosophy, and we got some good stories, and we got some great insights to how an excellent lawyer has had an exciting career. But we also got an insight into what it means to be over 65. You are, aren't you, Frank?
I'm 84.
All right. I wasn't going to say that. And enthused about life, with a reason to get out of bed, in the morning, and things to do and contributions to make to the legal world and to the growth of justice in America. So we thank you for your contribution. And we thank all the audience for watching.
Thank you all for watching, those of you who tuned in. It's been a delight. I am lucky that I have a great support system at home, a great wife. I have 4 wonderful children, 3 boys who are lawyers and a daughter who's married to a lawyer. And I have 7 grandchildren, none of which seem to be going to the law at the moment. But I've had a great life, and I feel blessed.
We all should be so lucky. So thank you very much, Frank, and thank you everyone for watching. And next week, we're off to look at some sculpture in Milwaukee, because Milwaukee has some really good sculpture. So thank you very much, everybody. Thank you, Michelle.
Thanks, guys.